Hi everyone, good evening and a very warm welcome to Thorough Newspaper Analysis. This is the video for the 3rd of July 2024. Now let's proceed and have a look at the pointers of discussion for the day. So first of all, we have the editorial segment, and here for discussion, we've taken up an Indian Express article, the title of which is On FIRs and Hearing of Accused, How BNSS Sections Fly in the Face of Supreme Court Rulings. See, in this article, essentially, we'll talk about two changes that the BNSS, it brings about in the criminal procedure law. And those two changes, they are in contradiction to two Supreme Court rulings, which are indeed, which were so far considered to be landmark rulings of the Supreme Court as far as criminal procedure is concerned. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So with that in mind, let's proceed further and let's have a look at the title of this article first. On FIRs and hearing of accused, how BNSS sections they fly in the face of Supreme Court rulings. Now let's proceed and have a look at the context of this article. See, as we all know, on 1st of July, and from 1st of July, the old criminal laws, they've been replaced by new criminal laws. So the BNSS, which stands for the Bharatiya Nagrik Suraksha Sanhita, it has replaced the CRPC, which is the Code of Criminal Procedure 1973. And with this replacement, two changes have been introduced in the procedural law. Those changes, they contradict landmark Supreme Court rulings. So the first of these changes, it include imposition of a 14-day deadline for police to register an FIR in cognizable cases. And second is the grant to the accused of the right to be heard before a case is formally established against the accused. Let's take up the first part for discussion first of all. So if you are familiar with the CRPC, you would know that there is a section by the number of section 154 of the CRPC, and it essentially provided for the registration of an FIR, correct? Now, if you peruse the wording of section 154 subsection 1 of the CRPC, you would realize that it essentially provides that whenever an officer in charge of a police station receives an information which discloses the commission of a cognizable offense, then there can be two ways. First of all, if the information is written, if it is received orally, then you have to do 2-3 procedural formalities. And if it is in writing, then you have to reduce the substance of that information directly in a register which is kept for the purpose. If it is given orally, then you have to reduce it into writing and then get the signature of the informant and read the information out to the informant. And then eventually, the substance of this information, it is reduced into writing. It is reduced in a register which is kept for the purpose. There is a uses of the word shall under section 154 subsection 1. It provides that whenever information about commission of the cognizable offense it is received, then such information shall be reduced into the register. Correct? The substance of it shall be recorded and reduced in the register. So that means the registration of an FIR in a case which discloses the commission of cognizable offense, it was mandatory and it had to be done then and there. And there was a judgment saying the same thing, which was the case of 2013 ruling of the Supreme Court in the case of Lalita Kumari versus State of UP, where the Supreme Court said that registration of an FIR in a case which discloses the commission of cognizable offense, it is mandatory, it is must. However, the Supreme Court said that there are certain eventualities where you can conduct preliminary inquiry. One of that was when, let's say, the nature of the information is such that the police is not able to figure out whether an offense, which is a cognizable offense, it is committed or not. Then for the very limited purpose of ascertaining whether the cognizable offense is made out or not in the case, a preliminary inquiry could have been done. And there were certain categories of offenses which were specified by the Supreme Court. Let's say matrimonial disputes or commercial disputes or cases of medical negligence where, there is a touch of civil or commercial nature disputes as well. There the police was given a liberty of conducting a preliminary inquiry and then deciding whether to register an FIR or not. So this was the law before the BNSS came into existence. Now let's talk about the change that the BNSS has introduced. So for that purpose, we have to refer to section 173, subsection 3. It provides, and I would like to read this entire paragraph out. So on registration of an FIR immediately, the BNSS under section 173, subsection 3, it states that for cognizable offences where the punishment is more than 3 years, but it is less than 7 years. So for those offences, a police officer is allowed 14 days to conduct a preliminary inquiry before registering an FIR and then proceed with the investigation of the case. So as per the law, the police will conduct a preliminary inquiry within 14 days, and this is to determine if there is a prima facie case to proceed or to proceed directly with the investigation upon finding a prima facie case. This change, it goes against the Supreme Court's ruling in the case of Lalita Kumari. This we've already discussed. So now let's jot out some of the differences which are there in BNSS provision and also in the case of Lalita Kumari. So while Lalita Kumari judgment requires FIR to be registered when information indicates the commission of cognizable offence, and it permits the conduct of preliminary inquiries solely to establish whether a cognizable offence is made out or not, the BNSS expands the scope. And how is the scope expanded? So under the BNSS, preliminary inquiries are conducted to ascertain if there is a prima facie case for offences punishable within this range. What is the range? More than 3 years or more, but less than 7 years of imprisonment. The BNSS, it applies broadly to all relevant offences within this specified quantum of punishment. But when it comes to the guidelines laid down in the case of Lalita Kumari, there were very specific categories of offences which were mentioned. For example, the cases of matrimonial disputes, commercial offences, or medical negligence cases. Now let's talk about the second kind of change. So the BNSS, it introduces a significant change regarding the right of the accused to be heard. Unlike Section 200 of the CRPC, Section 200 specifically provides for the examination of the complainant and the complainant's witnesses whenever there is a complaint case. And once the examination is done and the judge, the magistrate concerned, applies his judicial mind, then cognizance is considered to be taken. And after that is done, there are certain steps which are followed, one of which is the issuance of process, whereby either summon or warrant is issued, then the accused is brought before the court or he appears before the court, depending on what kind of process is issued. And then the accused is, briefed about the kind of allegations against him. He's given all the documents that are required to be given. So this is how the general the procedure governs. So first of all, cognizance is taken. And after the taking of cognizance, process is issued. By issuance of process, what do we mean by that? Section 204 of the CRPC, either summons or warrants are issued. Once that is done, the accused then comes before the court. But now here what is happening is, unlike Section 200 of the CRPC, which mandates that a magistrate can take cognizance after examining the complainant on oath, the BNSS, it does not require the accused to be heard before formal summons are issued. So Section 223 of the BNSS, while retaining the provision of examining the complainant on oath before taking cognizance, which is what Section 200 provides, it, however, makes a notable exception. What is that exception? It adds this provision: provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. So it is essentially saying that no cognizance of an offence shall be taken. You cannot take cognizance of an offence without hearing the accused or without giving the accused an opportunity of being heard. So this means that a magistrate cannot proceed to take cognizance of an offence without first allowing the accused to present their side. This is a departure from the established practice where the accused typically could not produce documents or arguments until after the cognizance stage. The Supreme Court, in its 2004 judgment in the case of State of Orissa versus Devendranath Padi, said that the accused does not have a right to produce documents to prove their innocence during the stage of framing of charges. The judge can only consider material which is produced by the prosecution to avoid a roving and fishing inquiry and a mini trial at the framing of the charges. The BNSS, however, provisions, it limits a judge's ability to take cognizance in cases where the accused is a public servant and the alleged offense occurred during the discharge of their official duties. The judge cannot take cognizance unless the accused public servant, is given an opportunity to make assertions as to the situation that led to the incident so far, which is alleged, and his superior officers submits a report containing the facts and the circumstances of the incident. The CRPC provisions does not have this wide exemption. It only exempts examination of the complainant when the complainant is a public servant and is acting in discharge of his official duties. If you give a read to section 200 of the CRPC and section 223 of the BNSS, you'll be able to figure out this difference more clearly. Now, with that in mind, let's proceed and have a look at the national news category, news updates. So this is the first update here. India has become the first nation to prepare full list of fauna. India, it has made history by preparing a comprehensive checklist of its entire fauna. By fauna, we mean animal species, let's say, which are located at a particular place or in a particular time frame. So checklist of its entire fauna covering nearly it's 104,561 species, becoming the first country in the entire world to achieve this feat. The Fauna of India checklist portal, this was launched in Kolkata by the Zoological Survey of India's 109th Foundation Day by Union Environment Minister Bhupendra Yadav. This is an important update. You may make a note of it. Next up is an update in the category of defense. So India has successfully developed and certified a new explosive, and this is 2.01 times more lethal than the standard TNT. SEBEX 2, it has been evaluated, tested, and certified by the Navy under its Defense Export Promotion Scheme. The new formulation, it has the potential to revolutionize bombs, artillery shells, and warheads, thereby enhancing destructive power without adding weight after extensive testing. Union Bank of India, it introduces Union Premier branches for rural and semi-urban markets. Union Bank of India, it has launched Union Premier branches tailored for high-value customers in rural and semi-urban markets. These branches, they offer personalized banking services and a wide range of products all in one place. Let's talk about Union Bank of India. So it was established way back in 1919. It is a public sector bank which is owned by the government of India, and it is headquartered in Mumbai, Maharashtra. Now, this reminds me of a question, and I would absolutely encourage all of you answering the same in the comment section. Year 1919. This holds a very important significance so far as the history of making of Indian Constitution is concerned. Could you go ahead and please just, point out what is the event concerned, which is important? Next up is this update. Sujata Saunik becomes the first woman Chief Secretary of Maharashtra. This is also important. Senior IAS officer Sujata Saunik has made history by becoming Maharashtra's first female Chief Secretary. She was appointed Chief Secretary by the Mahayuti government after Nitin Kari's retirement. Her tenure will last for about 1 year, ending in June next year when she retires. She is the second woman in Maharashtra this year to assume a prominent leadership role after Rashmi Shukla was become the first woman Director General of Police, DGP, in the state's history. So this is also an important information pointer which you may make a note of. The Ministry of Statistics and Program Implementation, it launches a portal which is called the eSankhyiki portal, and this is for enhanced data access. The Ministry of Statistics and Program Implementation, it launches eSankhyiki portal for enhanced user implementation, user experiment, and ease of data access. The initiative, it is in sync with the theme of Statistics Day, which is use of data for decision making. As ease of access of data, it is the prerequisite for evidence-based decision making. This portal, it has two modules, namely the data catalog module and macro indicators module. International segment for the day, and the first update is with respect to this. Mauritanian president comfortably wins re-election. Mauritanian President Mohamed Ould Ghazouani, he has been re-elected as the head of the state following the national vote, winning comfortably, taking over 56% of the vote in the first round without the need for a runoff. Chinese scientists discovered the plant that could survive on Mars. Chinese scientists have discovered a plant that could possibly be able to survive and grow in harsh climatic conditions that are posed by Mars. Scientifically, this is called Centricia canaversa. The plant, it can handle extreme cold, extreme radiation levels, and drought. The team's research explores growing plant directly on the planet's surface, a pioneering study on plant survival in the environment of Mars. Now, with this, we come to the legal updates for the day, and this is the first update that we have from the Honorable Supreme Court. Absurd, impossible. Supreme Court and High Court's condition that accused will get bail only if victim stands at surety. Now, in the past few months, there have been a couple of updates that we've seen in TNA as well, where we've realized how there are certain bail conditions which are imposed by high courts, which do not set well with the Supreme Court. And the Supreme Court has been time and again pointing out and, directing the high courts or the lower judiciary as well to refrain from and avoiding imposing these sort of conditions for bail. For instance, in the past few months, we've come across bail conditions like requiring the accused to have a rakhi tied by the victim, or requiring a politician not to participate in political rallies, or imposition of exorbitant amount of money as a security for grant of bail. So these have been so far instances that we've seen in the past. Now today is another such instance. Here the Supreme Court has expressed disappointment over an absurd condition for bail, which is imposed by the Honorable High Court of Patna, where the bail was granted to an accused on the condition that the victim of the offense should stand as a surety. Now, the court noted it is very unfortunate to note that because of such absurd conditions which are imposed by the High Court, the petitioner, although ordered to be released on bail way back in July of last year, yet is still languishing in jail. The name of this particular matter is Shravan Kumar Yadav alias Shravan Yadav versus State of Bihar. Next up is an update from Honorable High Court of Chhattisgarh, and this is with respect to the NDPS Act. So the Chhattisgarh High Court has made it clear that the mandate of Section 52A of the NDPS Act, qua drawing of samples for alleged contraband. Contraband is the narcotic substance which is captured. So for alleged contraband, it is fulfilled only when the same is done in presence of a judicial magistrate and not in the presence of a gazetted officer. Please understand what the court is held here. The court is essentially saying that the mandate of Section 52A of the NDPS Act, what does this section provide for? What is the mandate? It is providing for drawing of samples for the alleged contraband. Whenever there is a seizure, then the samples are drawn, correct? So whenever there is the drawing of the alleged contraband, the samples, then it has to be fulfilled in the presence, it has to be done in the presence of a judicial magistrate and not in the presence of a mere gazetted officer. The division bench of the High Court emphasized that the samples in question in the present case, they were not drawn in the presence of a magistrate, nor was there certificate by the magistrate, which is required in terms of Section 52A, subsection 2 of the NDPS Act. Drawing samples in the presence of a gazetted officer alone does not meet the legal requirement of the NDPS Act. The name of this particular matter is Chandra Shekhar Shivhare and another versus intelligence officer. Now, this has brought us to an end of our TNA. Thank you so much for watching, and please don't forget to put down your answer in the comment section. And in case you have any topic, any editorial topic, any recent social legal issue that you would want us to discuss in the editorial segment, please feel free to mention in the comment section, and we would absolutely be glad to cover that. Thank you so much for watching.